Judgment in the matter of Pimlico Plumbers Ltd and another versus Smith.
Lord Wilson will explain the decision of the court.
We all know that if someone employs us under an ordinary contract of service, we have various legal rights against him beyond whatever the contract provides. We also know that if we agree with someone to do a one-off piece of work for us, for example, to redecorate our living room, he does not have legal rights against us beyond whatever the contract provides. But over the last 50 years, Parliament has identified a middle category of working people to whom it has given some, but not all, of the rights given to employees under an ordinary contract of service. These people are now defined in Lim B of Section 233 of the Employment Rights Act 1996, so lawyers call them Lim B workers. Pimlico Plumbers Ltd operates a large plumbing business in London. Mr. Smith is a plumber. He worked for the company between 2005 and 2011. Then he made various claims against it in the Employment Tribunal on the basis, which the company disputed, that he was a Lim B worker. The tribunal concluded that Mr. Smith was a Lim B worker and that therefore it could, in due course, proceed to examine his claims. The company has been unsuccessful in challenging the tribunal's conclusion, both in an appeal tribunal and in the Court of Appeal. The company now renews its challenge in this court. Today, however, we dismiss its appeal. In agreement with the decisions below, we unanimously hold that the tribunal was entitled to conclude that Mr. Smith was a Lim B worker. If you're to qualify as a Lim B worker, you need to establish two things. The first is that you undertook to perform the work personally. If under your contract you can send anyone along to do the work, you don't qualify. We've looked carefully at Mr. Smith's final contract with the company. It's true that he appears to have had a right to send another plumber to do a piece of work which he, Mr. Smith, had agreed to do. But importantly, that other plumber had also to be under contract with the company. And the dominant feature of Mr. Smith's contract was that he should do the work himself. It obliged him to accept work within his skills. He promised that if he accepted it, it would be within his competence. And for example, it even regulated his appearance and the cleanliness of his uniform. We held that the tribunal was entitled to conclude that Mr. Smith undertook to perform the work personally. The second thing you need to establish is that the other party to the contract can't be regarded as having been a client or customer of yours. So, was the company a client or customer of Mr. Smith? We hold that in answering this question, it is helpful to consider whether Mr. Smith was marketing his services to the world independently of the company, or whether, on the other hand, he was an integral part of its operation, subordinate to it, and acting under its direction. If the latter, the company is unlikely to have been his client or customer. Although the contract did provide him with elements of operational and financial independence, Mr. Smith's services to the company's customers were marketed through the company. More importantly, its terms enabled the company to exercise tight administrative control over him during his periods of work for it, to impose fierce conditions on when and how much it paid to him, which were described at one point as his wages, and to restrict his ability to compete with it for plumbing work following any termination of their relationship. We held that the tribunal was entitled to conclude that the company cannot be regarded as having been a client or customer of Mr. Smith. So Mr. Smith wins the case, and the tribunal can proceed to examine his claims as a Limb B worker.